Hello, and welcome to the Candidate Forum for Los Angeles County Superior Court Office number 137, presented by the League of Women Voters of Los Angeles County. The League of Women Voters of Los Angeles County is composed of 10 local leagues. We are a nonpartisan grassroots organization working to protect and expand voting rights and ensure everyone is represented in our democracy. We empower voters and defend democracy through advocacy, education, and litigation at the county, state, and national levels. The League of Women Voters does not support or oppose any candidate for any office. We put on candidate forums as part of our voter service activity so that voters can listen to the candidates who are vying to represent them in county government. Los Angeles County Superior Court judges are elected locally or appointed by the governor for 6-year terms. In order to run for judge, a lawyer must be a member of the State Bar of California and have practiced law for at least 10 years. Leading up to the March primary, the LA County League of Women Voters is conducting forums with all the 9 contested judicial seats. They will be posted on YouTube and advertised through our websites. Our moderator this evening is Dolores Gonzalez Hayes. Dolores is a member of the Whittier League and has held positions as Senior Policy Advisor to a member of Congress, Executive Director and Policy Director in the nonprofit sector, National Community Development Manager of a national bank, and Housing Director in local government. Our candidates this evening have agreed to the League's rules, which require that they speak only about themselves and adhere to the time limits. We thank our candidates this evening who have made time to be with us in seat number 137. Michael Berg, Luz Herrera, Tracy Blount. Unfortunately, candidate Diana James was unable to attend this evening because she had a conflict in her schedule. So Dolores, let's proceed.
Thank you, Margot, and welcome candidates to today's forum. We will begin with your opening statements by each candidate in alphabetical order. So we will begin with Mr. Michael Berg, and you have 1 minute.
Hi, my name is Michael Berg, and I'm running for seat 137 of the Los Angeles County Superior Court. I was born and raised in Los Angeles. I am married. I have 2 daughters. My wife is also an attorney. I've been a lawyer for nearly 18 years, and I've been working in criminal defense since 2008. In 2009, I opened up my own criminal defense firm, and since then, I've been representing people accused of felonies and misdemeanors, but I also represent victims of crime. When I represent victims of crime, sometimes I have to go with people to file police reports because they're too afraid. So it can be that, or it could be going to court and letting their wishes be known. Or if there's restitution issues, I go to court and I get them the restitution. Thank you.
Thank you, Mr. Berg. Next, we will hear from Ms. Tracy Blount.
Hi, good evening, and thank you for having me. My name is Tracy Blount. I'm running for seat 137. I'm judge of the Superior Court for LA County. I have 2 daughters, and I grew up in the Altadena, Pasadena area. I went to UC Berkeley, and I went to University of Laverne College of Law at night. I work for LA County Counsel's Office. We represent the departments of the county. I work in the dependency division. In that division, we represent the Department of Children and Family Services. I have handled child abuse and neglect cases in trial court for the past, for about 12 years. And I've been at the warrant desk handling dependency removal orders for the past 7 years. Prior to that, I worked for the San Bernardino County DA's office in their appeals and practicing criminal law. And I was a paralegal for County Counsel's Office for 4 years. Thank you.
Thank you. Ms. Luz Herrera.
Thank you. Good evening. My name is Luz Herrera. I'm a candidate for Superior Court Judge, Office 137. I decided to run because I think representation on the bench matters and because I believe I have the experience, the temperament, and the commitment to justice that is needed for judges in Los Angeles County. I graduated from Stanford University and Harvard Law School. I've been a member of the California Bar for 23 years. I have represented clients in Los Angeles courts, but have also represented litigants in matters that never got to court. My experience in civil practice is diverse, from corporate law to family law to estate planning to civil litigation. And I have worked with varied clients, from large banks and big corporations to unrepresented litigants who seek assistance in navigating the courts. In addition to my experience as a lawyer, I'm also a law professor, and I've had the opportunity to practice alongside students and to think and write about the law and to train new lawyers. My work history includes creating legal services programs that aim to increase law and justice, and I ask for your support in this election. Thank you.
Thank you, everyone, for your statements, because it allowed us to know more about your candidacy. The following are questions to be answered by each candidate per the timing rules. You have 1 minute each to respond, and the questions will be the same for all of you candidates. And the first question is, what is your theory of punishment, and what role do you see for rehabilitation and treatment as an option other than confinement? And rehabilitation within confinement, in jail or prison, in the criminal justice system. We will begin with Tracy Blount.
Yes, thank you. My theory of punishment, that's kind of a harsh way to put it. I work in an environment in a dependency court where rehabilitation is built into the process. The judges in children's court do not send parents to jail. There may be a criminal case running with our dependency case, but the point of what we do is to reunify the family. So depending on what the issue is that brought the child into dependency court, that is what the judge will order a parent to do. In other words, if the issue is a drug issue by the parent, then the parent has to do a drug treatment program with random testing. If the issue is sex abuse, then the parent will have to do sex abuse awareness. So the point is to reunify the family through services by addressing the issue and not sending someone to jail. And as much as that can be done, I feel it should be done. Thank you.
Thank you. Ms. Luz Herrera.
Yes, I think there's an important role for rehabilitation, and it needs to be balanced with public safety. And it's important to understand the defendant or the party's background, the community of support that could help with rehabilitation, and also to consider the impact on victims or alleged victims. And so it's really important to have judges who can strike the balance, who will have empathy, who will consider the totality of circumstances in making an assessment of when rehabilitation is necessary and could be effective to really impact the community, not just the individual. I think we have to look at these cases in terms of how individuals operate within our society. And it's important that we have these specialty courts and other things, but we also need to make sure that people are held accountable when they need to be.
Thank you. Mr. Berg.
I'm a criminal defense attorney, and a lot of my clients have mental health issues. I'm a big supporter of mental health diversion. I want to stress that there are a lot of judges who simply deny mental health diversions today in court. There's no reason for these judges to deny these motions. If the person falls out of mental health diversion, the person is back in their original position. So confinement is still a possibility. Mental health diversion gives us an opportunity to try to help the person. The alternative is not dealing with the mental health issue at all and just putting the person in jail or prison. Putting people with mental health issues in prison doesn't work either. There is no mental health help in prison. So when they complete their time, they're just released, most likely a lot worse than they were off before they went in. Also, there are people who don't have mental health issues, and sometimes a short jail sentence is a good thing. I've had a lot of clients commit a crime and then commit the exact same crime. And then when we go back to court on the second time, the prosecutor wants prison. And I don't think you should send someone to prison for a low-level offense just because they've never had a taste of jail itself. Thank you.
Thank you. Next question. To what extent have you practiced criminal law, family law, complex civil litigation, and what types of clients have you represented? Ms. Herrera.
My practice has been primarily in civil practice. So I've done a lot of trials in law and motion in the family law area. As you might imagine, a lot of clients in the family law context don't have the money to take their matters to trial. So a lot of them end up settling. And in criminal law, I have very limited experience. Most of my experience in that area is really set through the civil context and administrative hearings within prisons. I did that for about 1.5 years, but I have not practiced in the criminal law area. The types of clients that I've represented range, like in the beginning of my career, I represented large corporations and real estate funds, real estate investment funds, but also in my law practice, when I had my practice in Compton, I represented modest income individuals and professionals. Most of my work through legal aid clinics that I've developed has been with low-income clients.
Thank you very much. And Mr. Berg.
I am a criminal defense attorney, and I represent a wide variety of clients and a wide variety of crimes, any type of misdemeanor or any type of felony. But I also handle parole hearings, probation violation hearings. I've done dependency cases, and I've also handled civil restraining orders. Thank you.
Thank you. Ms. Blunt.
Yes, thank you. I have practiced criminal law when I worked for the DA's office and did appellate work as well. I have practiced civil and criminal in dependency court because it's a unique crossover of both. I also, as a paralegal, did a lot of law in motion when I worked for in-house counsel. I did real estate and loan and finance for a couple of law firms downtown as a paralegal. And the client I represent is the Department of Children and Family Services. And as an agent of the Board of Supervisors for LA County, that's who I represent right now in court, working for county council. And there's a lot of crossover in dependency with family law, probate, education law, because we deal with whatever issues come up. And there are times when we have to research and handle whatever issue comes up with whatever area of law. Thank you.
Thank you. If you observed a party in your courtroom being poorly represented by an unprepared or ineffective lawyer, how would you handle the situation? Mr. Berg.
In a criminal court, having effective counsel is extremely important. Even during a plea bargain, the lawyer needs to explain the rights of the defendant and the waiver of those rights. If a judge sees that a lawyer is not prepared or incapable of doing their job, the first thing I would do is I would have to inquire the attorney, approach the bench, and find out what is happening, and then and then kind of make a decision on what to do next. Thank you.
Thank you. Ms. Blunt.
Yes, that has to be handled delicately because you can't really discuss things about a case and issues about a case ex parte. So I would try to gently nudge the attorney verbally to let them know what they need to do. Possibly have an off the record conference, just, to let them know that there's an issue with their representation and they might want to focus on a certain issue. Again, without involving the facts of the case, because you can't do that unless you have a full, a conference with all the attorneys present. So you don't want to see attorneys getting into an ineffective assistance of counsel situation because they're not competent or they're not doing their job. So the best way to do that is to try to just conference with them in a as open a manner as you can as a judge. Thank you.
Thank you. Ms. Herrera.
I agree that it's a delicate situation and it depends on the context. Obviously, in a criminal matter, you have to balance the interest of the individual that's being represented. And fortunately, there are lawyers in the courts that are able to assist and perhaps counsel these attorneys, because if the judge is paying attention to ineffective assistance to counsel, others are too. So I hope that there would be a little bit of peer support in that. But ultimately, I think what needs to happen is that we need to assess the situation and determine if the representation is so poor that that it requires a continuance of the matter. And to the extent that you're able to have a conversation with the attorney, it's important to explain to them the importance of being prepared.
Thank you very much. In the area of hate crimes, what are some of the issues in balancing free speech rights against the need to control offensive activity? Mr. Berg.
Because this is an issue that might come before me as a judge, I really can't answer the question under the ethics rules. But I will say it is important for judges to understand the seriousness of hate crimes and be informed about the constitutional speech protections and where that crosses the line into hate speech. Thank you.
Thank you. Ms. Blunt.
Yes, the same disclaimer as Mr. Berg gave regarding cases coming before me potentially as a judge, but I would say that there's a balancing test that has to occur regarding the actual crime and the free speech, potential free speech violation. Was the speech that was the speech at issue, was it specifically a threat to some individual, or was it just a general statement? That's the balancing test that has to occur with regard to hate crimes and free speech violations and hate crimes and hate speech, etc. Thank you.
Thank you. Ms. Herrera.
Obviously, we have to defer to the law and what the law instructs us in these situations. But I also think that it's important to be clear in the courtroom about what is acceptable behavior, and that everyone in the courtroom deserves respect. There's a lot of balancing that we have to do in these situations. But I rarely think that First Amendment allows for hateful speech.
Thank you. If you became aware of unethical conduct on the part of a trial advocate in a case in which you were presiding, how would you handle it? Do you believe judges should be required to report attorney misconduct? Ms. Herrera.
Having taught ethics in law schools, I do think it's important for judges to report unethical behavior. There are also other tools that judges have in terms of sanctions and other reprimands to counsel. But if there is consistent unethical behavior and it is displayed in the court, I do think that there is an obligation for the bench to make the bar aware of that.
Thank you. Mr. Berg.
I really can't answer this question because of the ethics rules, but attorneys are required to report unethical behavior effective August 2023 per Rule of Professional Conduct 8.3, which requires a lawyer, when they know another lawyer has done something dishonest or criminal, the lawyer is required to report that party to the state bar. Thank you.
Thank you. Ms. Blunt.
I believe it was regarding a judge reporting unethical behavior, and there is a requirement that judges report. They have to report. And that's my answer. Thank you.
Thank you very much. Now we come to the concluding statements by each candidate, and each of you have 1 minute. The concluding statements we will do in reverse order from the opening statements. So we will begin with Ms. Herrera.
Thank you for the opportunity to seek your support. I think it's important to consider that courts are places where individuals take very difficult issues that are very emotional to them. And it's important to have individuals there who know how to manage not just the lawyers and the docket, but the parties that are there and often are unrepresented. And we need judges who treat all litigants with respect, with fairness, and that's true regardless of their English fluency, their sexual orientation, or their ability to hire a lawyer. I have worked with diverse population of lawyers and litigants, and that experience will be invaluable on the bench. There are more than 32 Superior Court judges, dozens of elected officials and community leaders that agree that I'm a strong candidate in this race. My organizational endorsements include the Los Angeles County Federation of Labor, the Northeast Area Democratic Club, Latinas Lead, SEIU 712, and USW 675. Thank you for supporting my candidacy.
Thank you. Ms. Tracy Blunt.
Yes, thank you for having me. I really appreciate it and appreciate the opportunity to talk about these issues. I have been, as I stated at the outset, in trial court for years. I had the opportunity to not only try cases, but observe judges and what they do. And in dependency court, specifically, well, every court's dealing with heavy issues, but we're talking about child safety. The judges are the decision makers. They are the trier of fact. They have a heavy responsibility, and I understand what they do, what their burden is, and my experience, my broad experience in court on committees representing the county qualifies me to be a judge. I have a lot of experience in many different areas, and I appreciate your support in letting me speak tonight. Thank you.
Thank you. Mr. Michael Berg.
I do want to start with I am endorsed by Tim McCosker, Bob Hertzberg, Laura Friedman, Mike Gatto, Dario Fromer, and many judges. We need judges who are ready to serve on day one. I have jury trial experience. I understand the criminal justice system, which comprises the majority of cases in the court system. And I know how I can improve it. This is an election for a trial court judge. I've handled thousands of cases over my career. I've been in almost every courthouse in Los Angeles, all the way down to Imperial County to Santa Barbara and everything in between. I've literally been in front of hundreds and hundreds of judges. I know what works, what doesn't work, and I'm ready to work hard so I can have a just courtroom. And I am ready to serve day one as a judge. Thank you.
Thank you to all of you. Margot?
And on behalf of the League of Women Voters, I would like to thank all of you for participating in this candidate forum for judicial seat 37. We will be posting these forums on YouTube, and the link will be posted at the League of Women Voters website, which is www.lwvlacounty.org, as well as some of our other local league websites. The League of Women Voters also provides a free website for all candidates for office within LA County called Vote 411. And we appreciate the fact that many of our candidates, particularly for judicial office, have posted information on Vote 411. You as a voter can look for profiles of the candidates for county and state office at Vote 411. And by typing in your address, you will be able to access the list of all the candidates running on your particular ballot, and can look at the answers that those candidates have given to the league and compare the candidates based on the information that they have declared on the website. Of course, we encourage all of you to make your choices known between now and March the 5th. Whether you vote your vote by mail ballot and take it to a drop box or put it in the mail, or if you choose to go to a in-person vote center, and the calendar on the screen shows you when those vote centers will be open, starting on February 24th. The important thing is to become better informed and to make your choices and cast your ballot. Thank you very much.
Thank you, candidates.
Thank you.
Appreciate
Thank you
your
so much
time.
for participating. We
Thank you
really
very much.
Thank
And
you.
good
Bye-bye.
luck to